hour and thought it would do you justice and those who we represent to produce a scheme that was the gold standard for this, a model internationally. You've asked for a national scheme, it hasn't been forthcoming. But if you put forward a scheme that, as it were, demonstrates and I'm going to call it the rule of law. And part of the rule of law is natural justice, and part of natural justice is due process. Now, due process, like it or not, involves impartiality and independence. It's not a glib phrase, and it's not one that can be, as it were, safeguarded in the way that you have approached it.
Okay.
Some of the features that you suggest go some way, but actually what they don't do is guarantee fundamental independence of the decision makers. Now I want to, if I may, make a distinction, and forgive me for going on a little longer than the 3 minutes. Our scheme, and it isn't properly summarised on page 57 and the succeeding pages. You need to look at our scheme before you take a decision to see how we bolstered it. I'll come to the bolstering in a minute. Our scheme was intended, as I say, to be a gold standard whereby the initial decision, the important decision at the threshold of this process, is not taken by Lambeth in-house, it's taken by an independent panel member. Need only be one, not three, one. At the initial, and often that can be done not as it says in the summary. It's not going to take a lot of time to appoint a panel member. It's not going to take a lot of time for that individual, because a lot of this may be agreed between some people and council representatives. But it's not the council, nor is it Kennedy's, the solicitor, who are dealing with this. It is the decision maker. And it is, we say, and I'll have it confirmed, for example, page 57, the council has instructed external solicitors, well, if that's Kennedy's, they have been involved in child abuse cases before. So they're not going to be featuring and representing the independence that we have suggested here. So, independence throughout the scheme. There's a big confusion in some people's minds. Being a decision maker doesn't mean to say you're administering the scheme. There's a distinction between judicial decision making and administration. And it was envisaged, plainly, that there would have to be a substructure, if you like, a postbox into which the applications are fed and sifted, but actually the people doing that, the redress team, are not there to make the decision. They might be there to put the files together, ready for the independent assessor panel member, whatever it does. So these two things must not be confused. The idea, as it's put in here in your page 57 summary, that we were suggesting that it would be administered by the decision maker is wrong. That's not what we were saying. Now, it isn't just the independence sector that is so important to bolster the rule of law at the centre of this. Can I just ask a question? Have you all received the letter that was sent by Bernberg Pierce, Marcia Willis Stewart in particular, on behalf of SOSA, dated the 6th of December? Have you all seen it?
No.
I've had conflicting messages that you have or you haven't. Now, I'm not going to take up time because it would be another 15 minutes to read out the letter, but please, if you have access to that letter today, would you read it? Because that sets out in detail not only what we say about the need for an independent decision maker throughout, not just on the appeal, and not just an independent solicitor advising the person, but the independent decision maker who is the fulcrum of the whole process. But we then list in the letter 10 points which are not in the scheme. There are 10 points which are absolutely vital if you want an independent scheme, not just an independent adjudicator from start to finish, but that adjudicator is supported by the rules of natural justice. Now, I'm not going to read them all out. I'm just going to read out 3, and I'm not even going to do that. I'm just going to pinpoint what they are. So when you get the letter in a moment or two, would you please make a note? First of all, of the 3 points out of the 10 I want to make, there is no provision in your scheme, and I'm calling it yours in the sense proposed for your consideration today, for disclosure. Well, how's this going to work? Think about the case. Only yesterday, I know it was a criminal case, allegations of a sexual kind against a young student. What happened? In the end, during the trial, it all collapsed. Why? No disclosure, no proper disclosure. That's being examined. It has been the bane of the justice system ever since I started 50 years ago.
That's right. Wow.
And I hate to have to sit here and see that there is no adequate provision for disclosure. No point in in-house. It doesn't really matter if you're not going to get disclosure. If you follow, I think you're all recognising the significance. You would want it if you were on the other side. You'd want to know what files are held and what information is available, particularly in circumstances where, as you said yourself, there's an appalling dark history here, which is Lambeth overseeing not just abuse, being complicit in the abuse, and then being complicit in a cover-up. And then you expect, I'm sure when you start to think about this today, you may begin to have some reservations about the scheme that's being proposed. Right, second point. Second point. Actually extraordinary. That there's no provision in the scheme, your scheme, for the decision maker to give reasons for a decision. What? That is fundamental to any decision tribunal, that reasons are given. Now, of course, you can begin to rewrite it, but these are factors that we have been negotiating, liaising about for, as I say, nearly 11 months. That's the second of the 10 I want to just isolate. And then, finally, the one I'm isolating is that, yes, you have an appeal section, but what is absolutely vital again on an appeal? What would you want if you were appealing a decision? You put it in writing, that's one thing. But the next thing is, supposing the writing isn't going to persuade, you want the opportunity, which you've kindly given us today, to make oral representations. Why? Because there are things you can say face to face that don't necessarily come across in a written document. So there we have, I've just isolated 3. Look at the rest, and we say the scheme that you have devised does not satisfy the basic requirements of human rights law, and that's what we tried to do. Thank you for listening.
Points that you raised. I'm going to ask Alison McCain, who is the Director of Legal Services, to comment on those.